Or afternoon to all of you. Thank you for attending this month's SPSP webinar. My name is Ken Ross. I am the SPSP webinar coordinator and appreciate you all attending. Uh, you can see the title it's a long title for today's program, so I won't even repeat that, but we've got terrific speakers. We have actually a surprise speaker too that we're adding in. And before we do that, let me, sorry, I want to thank Sedgwick Brand Protection for sponsoring our webinar series this year, and they'll be sponsoring it next year too. We appreciate their support, and thank you, Sedgwick. Okay, we have, after today, we have two more webinars this year. Minimizing risk when buying or selling a business in November. And just to sell that webinar for a second, safety professionals have an important role in helping companies decide whether to buy a company or a product line and how to sell it. I would say over the years, safety professionals haven't been too involved in that process, but we are advocating safety professionals get more involved to the extent there are any safety issues involving the products being bought or sold. So, and then we'll talk about how to minimize that risk when you're doing it. The last webinar for the year, customer service and call center operations. We talked about that a little bit before, but we're going to go more in depth. And I will say that from a safety and a product liability standpoint and a CPSC standpoint, having bad customer service and call centers creates a bunch of problems for lots of people. This is an important topic. So we appreciate you considering listening in on those. Our speakers today, and I don't have our third speaker because it was just kind of a last minute decision to add her, but Matt Hauser is partner at the Cooley Law Firm, heads up the North American product safety practice. Matt is the former chief of staff of the CPSC and former ICFSO president. Second, Elliot Kaye, also a partner at Cooley. And Elliot is the former chairman of the CPSC. And our third speaker, whose name is not on there, I apologize, Asha Alam, who you all know because she's spoken before at our webinars. And Asha is within the legal group at the CPSC and acting general counsel, and she's also at Cooley Law Firm. So with that, I am going to stop sharing and turn it over to Matt to start talking about the subject. I think Lawden mentioned submit your questions. The speakers will see your questions. If it pertains to something they're talking about, they may answer it then. If not, we'll hold the questions to the end and try to get to as many as we can.
And
So,
Ken,
Matt?
if you don't mind going back to your going back one slide, or I guess you don't have to go back a slide, but I just wanted to point out that the two programs that you're going to be putting on in November and December are especially the December one. And in terms of the customer service and call center operations, are very pertinent and critical. We won't have time to get into all of that on during the conversation today. But of course, that's one of the places where all these things start, right? In terms of customer service and call center operations. So when we're talking about compliance programs today, I think that plenty of issues within or areas within compliance programs deserve their own deep dive. And I would highly recommend that one. And also, we've been on the other end of deals gone bad, as I call them, in terms of buying and selling a business. And that is something we've seen. If you don't do diligence on either side, things can go bad pretty quickly. So would highly recommend that one as well, just from our practical experience on both of those things, I think those are really great subjects.
Good. Well, thank you for the plug, Matt. I appreciate that. Okay, so now I will stop sharing and Matt will take over from there.
Absolutely. So, so while I guess the slide's popping up right now, we titled this internal awesomeness, and how to have a compliance program that CPSC respects. And so we're gonna go over that today, and we encourage questions. If you have questions, please put them in the chat. We will try and deal with them as much as we can in real time. I think we're all comfortable with that. And so if there's something pertinent to something we're talking about and you have a question about it, please, by all means, submit a question, and that will help to make everything kind of a lot more interactive. But our thought today was to kind of go through our practical real world experience and talk about a lot of these things and a lot of these topics, and talk about them in a way that is helpful and not just words on a page, and something that you can potentially apply. But there's nothing you can apply better than a question that you ask directly in the chat, and so please do that, if anything pops up that you have a question about. So I guess we can move to the next slide here. All right, decoding expectations. I'm going to turn it over to Asha to talk about this a little bit. Obviously, Asha, former acting general counsel at the CPSC, and was a senior trial attorney there, so knows a lot about what the current CPSC expects, as do we from dealing with them on the other side of civil penalty issues, and areas where compliance programs are really kind of scrutinized. But CPSC is sometimes described as a black box, right? And what are the expectations of CPSC? Come to ICFSO, and maybe can't say a lot in front of that large group, and so what's it like in the room, in terms of what the agency is looking for and what they expect, with respect to compliance programs. I think that's something all three of us can talk about. Asha from her very recent and relevant experience, Elliot as the architect of kind of modern CPSC compliance and enforcement initiatives, when he was chairman, and me from a lot of experience, on the other side of the issues since I came out of the CPSC. So I'll just start off by saying that the CPSC expectations with respect to compliance programs, and this is not going to be a surprise and is somewhat of a duh statement, is that they work, and that to the extent that they are functioning as they should, there really should be one of two outcomes as an issue goes through a compliance program. One, it results in a report to the CPSC, if one is warranted, and two, that if it doesn't, that there's a real reasonable basis for why there wasn't a report, and that is something that's kind of coded and described in real time, and is reasonable. There's a lot of what people call Monday morning quarterbacking, and I think that is made more prevalent in these types of discussions in terms of what the CPSC expects from a compliance program, where there's a void of information. You didn't make this decision in 2022 because, and you are filling in the blank, based on people's memory and things like that. And so I think just at a high level, that's something that I've seen and observed multiple times, with the CPSC, in terms of their kind of expectations from an overall perspective. But Asha, I want to turn it to you with the most recent experience, and probably dive into some more detail.
Sure. Thanks for that, Matt. So usually when you're dealing with a compliance program, you're dealing with the Office of Compliance. And, this comes up in a few ways. Most frequently, it's coming up on the front end when you're negotiating a recall or you're dealing with a Section 15 investigation. Folks who've done recalls recently, as well as 5+ years ago, might notice that one of the provisions in the corrective action plan agreement is a requirement for a compliance program. Now, a lot of folks have been resisting that for years, but interestingly, there are no details associated with what that compliance program looks like. And at the same time, if something were to, go wrong, the existence of a compliance program is something that is considered as a mitigating factor in the context of civil penalties. And so you would wonder, why is the CPSC essentially including this gift in a corrective action plan agreement that companies don't necessarily want to be forced to spend money on? That later benefits them. Ultimately, the answer is because there's this expectation that if you have a good compliance program, CPSC shouldn't have to get involved because companies can self-police, self-correct, self-address in real time. And then, functionally, you're just dealing with reporting in a timely basis and you're working as a partner with the agency. And I think that is the expectation, is that, whatever the company is doing in terms of assessing risk, assessing hazards, processing incoming information, they're doing it with transparency and with a view to protecting the public and keeping the agency in the loop in proceeding in that way. And so, as Matt said, the ultimate expectation is that if something goes wrong, it results in a report to the agency. But I think that what's really challenging is understanding what the basis for those expectations are and how they are actually transmitted to companies and in what context. Elliot, I don't know if you had other thoughts on that as well.
Nope, Your Honor. I'll keep going, Austin.
Well, so I mean, I think the one thing I was going to say is I think that this idea of having a program that's going to ensure compliance. When oftentimes we know you can't predict the unpredictable, which is what we're doing here when we're dealing with hazards and consumer behavior and recall requests. So this idea of, well, how do you figure out what exactly the CPSC is looking for when in terms of how you achieve that outcome? And so, we have the good fortune of some resources that the agency has provided. So compliance program resources, the CPSC does provide some guidance on what a compliance program should look like in the context of, most specifically in the context of a civil penalty settlement agreement, but also in the context of the recall handbook and manufacturing best practices. And we'll make sure that these slides are circulated so folks have these links available to them. Now, if anybody has been involved in a civil penalty investigation that went all the way to a negotiation, you would be acutely aware that the Department of Justice works very closely with the Office of Compliance in navigating everything from the case assessment to vetting the demand that's going to be transmitted to a company. And so something that is relevant but not necessarily binding on the agency are these, sentencing guidelines or criminal investigation related mitigation provisions. And so DOJ, both in the antitrust division as well as in the general criminal division, has published some guidance on how compliance programs can be considered in order to provide credit or a reduction or some kind of favorable factor consideration. And the Department of Justice manual does provide guidelines for taking into account a company's efforts to essentially prevent the infraction from occurring again. And so all of that is to say, there are these resources. They are quite general in nature, but they do exist, and I think the expectation is that companies are using them. So we have an example that we'll put up just so you can see.
I was just gonna jump in real quick and just say that this is these resources they're guideposts, they're signposts, they're helpful. Of course, every compliance program the CPSC expects to be bespoke to a specific company and their processes, and they actually get pretty far in the weeds actually in terms of the analysis, depending on who is looking at it at the agency. And we've gotten some questions along the lines of, well, isn't it supposed to, the process supposed to work this way, and this person would have been looking at it, or this department had the responsibility for looking at it, and so I think that again, these are general and they're high level in terms of some of the things that they talk about, and especially the DOJ guidance is in some ways way beyond what would be required for a CPSC reporting compliance program is really what I'm focusing on here. But these are things that are general principles to be captured, but the operational aspect and seeing what happens when they're looking at the emails, the documents, the Teams messages, whatever it may be, because if you're in a civil penalty investigation, that's what's happening. That's what they're looking at. They're looking to make sure that the policy makes sense from the perspective of these overall global type of high level areas that the compliance program should cover. And then what's actually in the compliance program is matched by what happened in the emails, the documents, and the Teams messages, and the procedure that all of the document production in a civil penalty shows. And okay, did you follow your procedure? And can they trace it by looking through those documents that you're going to produce to show that actually the investigation, the program worked as it was supposed to, and we can see where they got at this point in time. And that's where I think Asha is going to talk about prosecutorial discretion later kind of can come into play in terms of some of the ways that the agency may look at it.
The question came in just while on the slide. You're referencing Department of Justice guidelines, guideposts. Does the CPSC consider those also, or are you just suggesting that's something companies should look at, but that the CPSC wouldn't have an expectation you would comply with those kinds of criminal guidelines for criminal prosecutions?
I would say
And
that
I'm not seeing the questions, by the way. Maybe
it's
that's just me, but
you have to go
Okay.
to the Q&A,
all right,
not the chat.
I'll find it.
I would say that, they're not expectations. I mean, keep in mind that a lot of this is voluntary process, right? On the front end, when you're dealing with the CAP negotiation, the corrective action plan agreement negotiation, you're in a voluntary posture. The guidelines are helpful. The guidelines, if you look at some of the recent civil penalty agreements that CPSC has issued, they track. And so, I think that they're not mandatory, but there is alignment happening there. And there's a reason for it. The programs work, right? The idea is that DOJ has developed some best practices in terms of actually demonstrating prevention efforts, demonstrating, the kinds of protections and corrections that are needed to prevent an infraction from reoccurring. And, based on those best practices, why wouldn't the CPSC look at them? And so, it's one more resource to the agency, and therefore it's one more resource to companies that are looking to comply with the CPSIA and other acts administered by the agency.
So I'm just going to jump in here for a second, Ken, on that question, which I really appreciate, because as Matt mentioned in the beginning, this has been an evolution. And we started this back in the early 2010s when Inez was the chair and Matt and I were working for her and starting to put compliance programs into civil penalty agreements. And then we started to evolve it over some staff resistance into CAPS. It's a moving target. And the relevance of these DOJ guidelines, to me at least, is it's better to stay ahead of the agency. And companies that are at least looking at and considering the DOJ corporate compliance program provisions, there's a lot of good questions in those that companies should be asking to at least develop a more thoughtful approach, still pegged to reality and still pegged to what can be done at that company. And to Matt's point about being bespoke, that's realistic about how that company may operate, your company in particular, whoever you are. But I think that it's better to stay slightly ahead of the agency, because at some point, as the agency continues to modernize and get more and more like its sister agencies, it will get there, where it turns something into maybe an occasional guidance into something that is much more internally followed and then pushed onto companies.
And just a last thing on that question, because I think it's a really good question in terms of the relevance of looking at this. I will say I have not been asked directly. You're not following the DOJ corporate compliance program provisions. That's not, why have you? Did you look at those? Have you followed those? No, that's not a direct question that I've faced in a civil penalty investigation. Have I really, really enjoyed the fact that a client did and that we were able to say that in some way, shape, or form? Yes. And I think that is the difference there. It's less looking, it's more of looking at it in offensive or protective sort of way, and what you can say about how you built your program and what you based it on, more so than if you're going to get dinged for not having looked at it, if that makes sense, to answer that question as well.
Yeah, let me just throw in one thing on that. I mean, it's like considering best practices. What are companies doing? What does the government expect them to do? You always want to be as good as or better than everybody else. You'd like to try to do that. So considering these things, whether you adopt them or not, to be able to say that you've done that, you're aware of what the requirements are, you've adapted these best practices to your own company and your own situation, I think is good. But you don't, as a legal matter, you don't have to comply with those things. They're just guidelines anyway. So I think that's always good. Similar to safety standards. We always want to, we're not legally required, except the mandatory standards. We're not legally required to comply with voluntary standards, but we want to. We want to show that we are serious about safety. We consider things and compliance, and other people are doing it, so we want to comply also.
And one question, just kind of a timely question for Elliot and Asha, because I think a lot of people probably don't know the answer to this question, is what's happening with civil penalties during the shutdown, as a first question. And then secondly, what's happening with civil penalties under the new administration, and under acting Chairman Feldman's leadership?
Ashley, do you want to go first?
Have at it, Elliot.
So the first part of that is that the staff is not permitted, based on the interpretation of what is allowed to be done during the shutdown. The staff has not been allowed to work on civil penalties, so they're all frozen. All the investigations, they won't even open emails and look at them. They won't even acknowledge that they can't read your email. And so anything civil penalty is off the table. If you're having a different experience, let us know. That would be important to know. And in terms of Peter, this could be a topic of a whole webinar in of itself, but historically, as many of you know in the space, when an administration changes parties, you see a pendulum swing between one side, which is usually much more active and pro-regulatory and pro-enforcement, and the other side, which is more laissez-faire, more pro-business, more voluntary efforts. And Peter has been the exception to this. He likes to actually brag that he's more pro-safety than his immediate predecessor. And so we are at least seeing the same thing on civil penalties, where he has this drive to, again, he's public about this, to sort of break all records. And so he hasn't yet broken a civil penalty record from the CPSC, but I would expect him to be giving it everything he's got to do so.
I think the only thing I would add to that is, I think that posture is consistent with the sort of law and order approach. The law is the law, and if you break it, there is a posture that would insist on, accountability for breaking the law. And I think that that is consistent, that has been consistent over both terms that the acting chairman has served. But I think that, we haven't seen those investigations slow down. And so I think that that is an important signal that, these compliance programs, these enforcement measures are here to stay. And so with that in mind, we wanted to show a sample of, we mentioned that on the front end, before there is an infraction, when somebody is in just a recall negotiation posture, there may be in a CAP agreement a provision that says you will create or maintain a compliance program. But the question becomes, what does that look like then if you then get in trouble for not reporting timely and you're in a civil penalty posture? What kinds of provisions does the CPSC expect to lead to a timely report or a complete report of information that is reportable under Section 15 of the Consumer Product Safety Act? And so, we won't read all of the provisions here, but as you mentioned, you can kind of see the alignment between the provisions here and those in the sentencing guidelines that DOJ has issued. Everything from written standards and written documentation, tracking, quality standards in terms of the type of information, culture of compliance that goes all the way from the bottom to the top. And continuous improvement processes to make sure that, the policies are keeping pace with the business. Matt or Elliot, I know you guys were instrumental in sort of this evolution of the more rigorous program. Do you have any thoughts on some of these provisions?
Yeah, and you touched on it earlier, Asha, in the sense that there's no internal process and guidelines and specific criteria that they follow. And so it's pretty wide open, outcome oriented, certainly in terms of how it's drafted. That gives a lot of room for companies to do something that is completely, consistent with this, but works for a company, and to go in and make the case. Because obviously what happens with these is that you've got a requirement usually for that audit, which is mentioned in Section 9 at the bottom on the right. So you have to 3 times at least produce some type of written documentation as to how you are implementing this. That doesn't have to be limited just to writing. It can also be a phone call or a meeting and a chance to basically state your case and to try to get back into better graces with the agency. But there's a lot of room in here. And a lot of this, I think, is dependent on understanding that Mary Murphy, who is Asha's boss and who runs the cell division, compliance and enforcement and litigation, and is really going to be the person who's going to be scrutinizing these things the most, like understanding Mary and what motivates her and what she wants to see out of a company, and tailoring it to appreciate that the leadership of the CPSC has something in mind about behavior and being mindful of that, as opposed to just trying to check a box and have the bare minimum here.
And so I think with that, we can move on to the next slide. I think that.
I'm sorry. Excuse me. I just thought of a question on that. While you have it up there, it talks about annual internal audit of the effectiveness. What do you think they're talking about? I mean, how that's kind of open ended.
Totally.
Do you have to have a full-time auditor? Is it who does the auditing? Is it the financial people? Your outside accounting firm? What about external audits by safety professionals? Would that be required, or actually would it be a good idea?
But I mean,
So
go ahead.
Asha. No, please go ahead.
I was going to say, I mean, Ken, I think that's the sort of theme here, is that all of these provisions are very general, and they don't actually prescribe the implementation. They're all outcome oriented. You need to have an audit, but it doesn't tell you who does the audit need to be by. I mean, if we were talking about, general accounting practices, right, you would know it had to be a third party external auditor doing an internal audit. This is all amorphous. I mean, this looks, compared to the agreements of 10 years ago or 15 years ago, so detailed, but it really doesn't tell you as a company, what do you need to do in order to achieve these outcomes? And so you need to, for each of these 3 years, you need to have an internal audit accomplished that checks all these things to make sure that it's operating at, in best practices, and any problems that have been identified are being corrected. But it doesn't prescribe how you get there. And I think that's where a lot of companies end up tripping up.
Well, in the past, there have been several settlement agreements, civil penalty settlement agreements that require the company to get an external monitor.
Yeah.
And I haven't seen that recently, and I don't know why those particular settlement agreements required it. Maybe the company was particularly bad or not. Do you have any of you have any insights on when the CPSC might require an external auditor?
I think that there's a few things that are indicators there. One, and I think Acting Chairman Feldman's been very open about this, like he is about a lot of things that are important to him. One is repeat players in terms of it's your second or third penalty. I've seen that in his statements of where he may be looking for the third party monitor, and then secondly, it's just the more egregious cases, right? That have fact patterns that are just something that look a lot worse than others if you put them all together. So I think that those are two at least indicators. The Chairman Feldman was kind of on his own in terms of putting that into public statements in the prior administration and penalties, saying that he thought that there should be third party monitors. So as Elliot said, in terms of his focus on compliance and enforcement, we would expect to see that potentially in the coming months or years, whatever it may be.
I think it is also a reflection of, like, can you as a company be trusted to check yourself? And if you don't have an internal compliance program, or you do, but it's blatantly disregarded, there's no enforcement, there's no training, etc., then you're making the case that you can't be trusted to police yourself, monitor yourself, and hold yourself accountable. And that would weigh in favor of bringing in a third party. Now, my understanding, not having had to pay for one of these, is that the third party monitor may cost more than the civil penalty itself. And so it's something that companies, again, we think of compliance programs like an insurance policy. That's another way in which you're preventing a worse scenario by investing on the front end before you've had a big problem.
Yeah, let me point out one other thing that we're not going to talk about today particularly, but is that the use of these compliance programs or the lack of compliance programs in a product liability case. And in that setting, plaintiffs' attorneys, plaintiffs' experts can argue that your program was deficient, you were negligent, of course, argue that the product was defective, but they can make you look like a bad company if you really just have a written program that's not effective, that makes it look like you're trying to do something, but you're not really trying to do something. So a lot of these, the adequacy of a lot of these compliance provisions could be challenged in a product liability case to support punitive damages or other things.
So with that, like, if there are no more questions, let me move on to the next slide. We want to make sure we get through all of these secrets that we wanted to share. As we previewed just now, I think what's really important and is not spoken in these seemingly specific provisions in these settlement agreements or in the DOJ guidance is really, how do you actually implement these outcomes that are desired? And so, one of the things that Matt alluded to this earlier, is that there's no one size fits all. It's really about knowing your business and making sure that you understand where your vulnerabilities are, and how to make sure that the different divisions within an organization are working together to avoid the kinds of silos of information or decision making that ends up leading to the violation that the compliance program is meant to prevent. And so, we kind of can think about we can kind of think about this in terms of information that comes in to the company, right? The analysis of that information, and then the information that is going out of the company, to the CPSC, to the public, et cetera. And so, a lot of times the focus is on the decision-making process, but what that ignores is whether or not The inputs are actually going where they need to go. People oftentimes focus on customer service alone. And you'll see that customer service is then siloed, or when the CPSC issues a full report request, you get customer service records, and then they're coming back and asking, well, what about warranty records? What about testing records that the engineers have put together showing failed tests and things like that? And so, on that information input side, this isn't about information coming into the company. This is information from any location, external or internal to the company, going to the decision makers or the folks on the product safety committee, whoever that is, the CEO, that is going to be actually weighing whether information is reportable. And in order to kind of have that 360-degree view, it's really important to have an effective compliance program really get into the weeds on, who's doing what, who's collecting what exactly is being collected. So for example, and I know we touched upon this earlier, and I think Ken maybe alluded to an upcoming one on collecting customer service information. Oftentimes, for example, we see a lot of reports that companies have of, especially if they're working on, products with batteries or whatnot, explosion, overheating, fire, and customer service will just record that information. But having an effective compliance program means managing that incoming information effectively and asking follow-up questions, not just to, record whether, a consumer sought medical attention, but to affirmatively record that they didn't seek medical attention, or, not just to ask the amount of property damage that may have resulted if there was an allegation of an explosion, but to document that there was no property damage despite the characterization of an incident as an explosion or a fire. Really making sure that the compliance program provides guidance on data collection that the engineers would then actually use to assess a hazard and inform the product safety committee on whether prospectively, whether you're dealing with something that is likely to cause injury, or whether this is, really more of a quality issue or an aggrieved consumer issue. And so I think all of that is important on the input side, and then making sure that if you have, a few customer complaints and some warranty issues, that, the left hand and the right hand are coordinated to make sure that you're getting ahead of things and that they're informing the business folks and the legal teams of concerns that they have in a timely manner. And then I will just add that, once that information is received, the question is, you get into this product safety committee, really making sure that the compliance program specifies like what are going to be the criteria that are considered in determining whether information is reportable, who gets the final say if there isn't a consensus within the committee, who is going to be considered a person capable of appreciating the significance of information, because that's the standard that the CPSC uses to determine whether to impute knowledge of reportable information to an entire company, and making sure all those triggers that are in the CPSC regs and in the statute are really accounted for in your compliance program, so that you are following the protocols that you are actually going to be judged by. And, ultimately, if you're doing what CPSC is expecting you to do and you're following the steps that they're judging you by on the back end, there's really not much more you can do. And so that's the insurance policy, is if you get it wrong, there's still nothing better you could have done. You had a bad judgment call, but it wasn't intentional. It wasn't negligent. It was that you reached the wrong decision, but you considered all the right facts. Matt or Elliot, I don't know if you had anything on that in particular.
Well, first of all, we are so fortunate to have the benefit of your recency and your seniority there in two different positions, and understanding the internal parts and how it's interpreted in the current version of the agency. So there's not a ton to add to that, Asha, which is a good thing. I would just reinforce your final point that certainly Matt and I saw this in our time, and I'm sure you saw this in your time, that a lot of companies just didn't have anything to show for having made a decision. And of course, every inference is used against them by the agency. The agency assumes bad conduct, frankly, because it's easier to assume that and then not get burned. And so going through this process, documenting it, having a final non-privileged version of memo to file, and deciding not to report is totally legit if that is a reasonable decision to make. Like, that is okay. It just requires then that extra step of taking the time to go ahead and being able to show your work if you're ever pushed. And that's that step we don't see companies do often, and that we try to counsel companies to do more of, is take that extra time when they have put in the thought and they actually have a good process to show for it, and they've done testing and they can make a reasonable determination that there is no reporting requirement. Put yourself in a position to be able to demonstrate that if the agency comes calling.
Can I get one clarification on that? You said non-privileged memo to the file.
Correct.
Can a company receive legal opinion from whether it's an in-house lawyer or an outside lawyer concerning the legal duty to report? And how does the CPSC view that, whether the advice is correct or not, and or whether they want to quibble with it? Does it look like the company at least sought expert advice from a on a legal question, got advice, has no legal responsibility to report? How would the CPSC view that as far as whether they disagree with it?
Well, I think Asha's going to give you the better answer, but I would just say if it comes from Cooley, they take it very seriously. No, I'm kidding.
I was going to say, I think, so I have always taken the position that the regs include this sort of informal safe harbor. It says you have to report unless you've investigated and determined that the information is not reportable. So that is exactly, what you're talking about, Ken. It's an affirmative determination that information is not reportable. Now, I would have concerns counseling a client to turn over an opinion of counsel or a legal memo because of subject matter waiver considerations. And so that's why, we emphasize a non-privileged memo. But I think the point of having, even if it's like a checklist of these are all the categories of information we considered, and here's why the engineers or the product safety folks think that this is not reportable. The reason for documenting that sort of negative determination that, this is not reportable is so that you're essentially undermining the knowledge element that is a core component of these civil penalty investigations. You lack subjective knowledge that you had reportable information if you have documented that you believed after doing your due diligence that it was not in fact reportable. And so, when the agency is looking at these cases, right, these reporting failures or these misrepresentation issues, what they're looking for is either negligence or ignorance or willfulness, et cetera. But if you've now said, here's all the information, we are accurately looking at all the information we have, we don't have siloed things that, didn't make it to the right people. We've got all the facts in front of us and we are containing them because of the fact that, we don't think there's a likelihood that this injury is going to occur again, or, we don't think that any injury that might occur will be severe, significant, serious, et cetera. If you've done that analysis that CPSC instructs companies to do in its regulations, even if you land in that wrong outcome, it wasn't a result of ignorance, negligence, or willful, concealment. And I think that's important. So I think we wanted to also, kind of get into some of this in the, in the same vein as talking about mechanics, how does that differ whether you're a manufacturer or a retailer? So I'm gonna ask Elliot or Matt to kind of weigh in on this one, on the, since they've had a lot more experience kind of navigating this issue on behalf of clients and really kind of seeing what kinds of information comes across.
So I will hit that. I wanted to say one more thing on put an exclamation point next to what Elliot said on the memo to the file. We constantly see that not be done. It's like all the wins out of the sales after, you decide not to report, or you get the email from the outside counsel saying you don't need to report, you don't need anything else. You're never going to give the email from outside counsel, or you shouldn't give the email from outside counsel except in exceptional circumstances to the CPSC. So you need something else. And we see more often than not that something else doesn't exist. And so that's, really, really big thing that's really helpful if you're in that situation. Yeah, manufacturer versus retailer compliance programs. We have a lot of experience in both of these and dealing with the CPSC on both of these. And it's an interesting dynamic. Obviously, there's been lots of civil penalties that the agency has issued against retailers, where they believe that the retailers, either because they're the direct importer and therefore the manufacturer, or just as a retailer, had sufficient knowledge and should have reported. And one of the things that we see, not as much anymore, but we did see for a while, but I still see in some cases, is a belief among retailers that just informing their manufacturer about an issue and forwarding them complaints is sufficient. And that's part of their overall compliance program. And of course, the CPSC looks at it completely differently in the sense of the retailer and the manufacturer having an equal reporting obligation. There's no difference between the reporting obligation of the manufacturer and the retailer, except in one very important aspect, which is that the retailer, with a initial report to the CPSC, has a fewer data points that a retailer has to give to the CPSC and a distributor as well, versus a manufacturer. The CPSC is always going to want to go and get a full report from the manufacturer, which is the 14 bullet points in the reg versus the 5 that you have for the initial report. And so retailers and distributors, where they're truly retailers and distributors, are held to really just kind of providing that information. And so there's a lighter kind of what do you need to serve up to the CPSC difference. With everything else, though, it's really the same. And so it's somewhat of a trap for retailers, because retailers don't have knowledge of the product in the same way that manufacturers and importers might. But yet retailers are the ones that are most likely to receive the complaints, because the consumer bought it from the retailer and they're going to go back to the retailer. And so the retailer is held to the same standard as the manufacturer in terms of having an obligation to report. And of course, the usual trick is the retailer saying not just, hey, you need to report, and encouraging the manufacturer to do it, but to say to the manufacturer, you report or we're going to report as of X date, and compelling the manufacturer to do that. And a lot of times, because of the obligation that retailers feel that they're under, and they feel that they have the leverage over a manufacturer to get them to report, if they do that they'll go that way. The thing that I see often left off is that's taken on kind of faith and credit. Our manufacturer told us they reported, and that's fine, and usually that's the case that they did. The CPSA safe harbor that Asha was talking about earlier, though, for retailers is actual knowledge of reporting. And so from our perspective, there's really no substitute to not only the manufacturer reporting, but also the manufacturer providing the report to the retailer, or at least providing proof of submission if it's a fast track portal recall, or something like that submission. And so that way the retailer has that actual knowledge. In terms of manufacturers, of course, the agency is going to expect a little bit of a different type of program, and one that's going to be looking at everything to do with the manufacturer design of the product and things that are going on with it as well. And so the manufacturer, if they're making a design change, for example, is that a trigger within the compliance program? Not every design change, of course, because most aren't safety related, but safety related design changes, is that a trigger and an inflection point for potentially reporting to the CPSC? And then when that was done, did the company report to the CPSC? Looks like we got a question here. Ken, I don't know, you want to read it?
Well, one of them was, where are the bullet points you referred to for retailer versus manufacturer? Did you already talk about that?
Oh, I don't think that did I say anything about bullet points?
You mean in the reg, Matt? The difference
Oh,
of
the reg. Okay, yeah. The 1115.13 C and D. C is distributors and retailers. So 16 CFR 1115.13. C is retailers and distributors, and D is the full report, which is what they require manufacturers to send.
Okay. Do you see the next question there, Matt?
If retailers
Yep.
aware that a product is non-compliant with the CPSIA, and there's a later incident with that product, is the retailer potentially on the hook for not having reported it? It's a matter of non-compliance, but there's no incident, injury, or product defect. Is there a duty to report on part of the retailer?
Yeah, absolutely.
Yep.
Yes.
No question. I think this is one of the few areas that the statutes are quite clear. So Section 15 defines a substantial product hazard to include a non-compliance. And so, with these regulatory violations, non-compliance with the mandatory standard, you don't have to wait for an incident or an injury. If you have knowledge that a product is non-compliant, that is reportable information. Failure to report in a timely manner, and keep in mind that the statute and the regs require a report immediately. If there is an investigation, you get 10 days unless a longer period is reasonable. And so, as soon as you find out that there's that kind of non-compliance, you have a duty as a retailer to report. Unless you have actual knowledge that the commission has been adequately informed of that non-compliance by the manufacturer or another party, which is, not always the case. So with that in mind, we flag that there are these differences. One of the things we wanted to talk about also is, what is credit for compliance? You hear, about this compliance program. It gets lip service in the cap agreement. It comes up pretty significantly after you've lost the opportunity to get credit in the civil penalty settlement agreement or consent order decree. But how do you actually get credit for a compliance program apart from those two instances where it comes up? And so, I think this is something that is maybe a little controversial, definitely debatable. I'll let Matt and Elliot answer this one first, because I think I have a slightly different gloss on it but I do want, before we kind of
I
answer
think
it,
our gloss is the same actually, but and I agree with what you're gonna say, I think, but I would say that a lot of clients are frustrated because they're wondering, what credit did we get and how can you articulate that? Like we're fined 13 million, that's what the CPSC's demand is, versus what? And when you're going in to negotiate with the CPSC, they say, yes, we took that into consideration, and it's mixed in with all of these other things that we took into consideration in the civil penalty factors. And so they will say that you got credit for compliance. They will also tell you when you didn't get credit for compliance. We've had that before, and so, but will they attach a figure to it and say we reduced it by this amount? Because no. So you're never going to be able to quantify what that benefit is and what that credit is. But I think there might be a greater quantification that Asha's going to talk about. But Elliot, you want to add anything first?
I mean, honestly, the credit you're going to get is that you're going to avoid the situation in the first place, meaning your compliance program is going to pay off, and you're not going to end up at this late stage where you're begging them to give you this kind of credit. That's the incentive here. If your incentive is to try to wait until that stage and show them your compliance program and hope you're going to get credit, I would not recommend that. And I think all the investment in this will pay off on the front end, but I would not expect a lot of back end credit. And the primary reason for that, frankly, and it goes back to what I was saying about breaking records, there's such internal pressure to not allow lower civil penalties than what the trend is. And they don't happen that often, meaning civil penalties don't happen that often, that if there is a case that has a lower one, it messes up their trend, frankly. And they spend years having to dig out from under every company after saying, well, we want to pay that little amount too. So they don't want to give any benefits and any breaks that lower the amount. They want to keep all the pressure is to push these higher.
Yeah, I think, we put up the slide and you can read it later, but essentially, I wanted to emphasize that, the idea is that you may give credit even if the program fails to actually prevent the infraction. Now, these are DOJ's, different provisions. And I think in the antitrust provisions, they actually, in some of the sentencing guidelines, they do give a quantitative, 3-point reduction. CPSC doesn't work that way. But I think that the point at which you're negotiating a civil penalty settlement after receiving a demand letter, it means that the compliance program was not effective in undermining knowledge of reportable information that did not result in a report. And so CPSC's position has been, it must not be an effective compliance program. So why should you get credit for it when it did not actually function the way that it was supposed to? And again, this isn't about preventing the infraction where, you didn't report. It's about the knowledge component, because for CPSC to get to the point where they're sending a demand letter, it means that not only did the infraction occur, but there was knowledge, there was, a degree of culpability there, because that is one of the elements of, any of any liability for the prohibited acts requires a degree of knowledge. And so, what I would also add that where you get the credit then is either when at the end of a recall or, at the end of an investigation, when CPSC is questioning whether there's a basis for a civil penalty, that's where you get the credit, because the existence of a good, continuously improved compliance program means that, information is making its way where it needs to be, where it needs to go, and it's being evaluated with the right lens. And so if there is a failure to report immediately, or if there is some kind of violation, it's not being done knowingly, or after, and so then you don't even get the civil penalty investigatory letter, or you get the letter, but you don't get a demand letter because of the fact that you've produced extensive records of this compliance program. You've produced evidence showing that the program's actually followed. And it may be the case that the calculus came out wrong in terms of assessing risk. But the point is that using all of the information available to the company, the decision makers made a determination that information was not reportable based on their assessment of the correct facts. And so, go ahead, Matt.
Yeah, I was just going to say, just to put a fine point on that, to Asha's point, we have had cases where the CPSC has investigated and they have not pursued a civil penalty and they've closed the investigation. And I think that some of that has to do with exactly what Asha was just saying, and that we're able to tell a good story and we're able to walk the CPSC through it. And that's happened multiple times. And so it's not the outcome every time. The CPSC obviously investigates cases where they think they're going to find a violation, but sometimes they don't. And so, that is really, something that is a real outcome here. And I think is the right way to focus on it, rather than how much is it going to knock your penalty down, right? As Elliot was saying.
Right. A good civil penalty, a good compliance program makes your violation innocent. And I think that's important here, because what the CPSC needs to prove is that it was not innocent. It was at least negligent. And so, just undermining those legal elements of liability, that's really where you're recouping your investment in a good compliance program where the practices mirror the documentation. So with that, we wanted to get to this last slide. We've sort of alluded to it throughout the presentation, defensive benefits. We talked about this sort of safe harbor where you're documenting your decision process in a non-privileged manner so that you can show that you did consider the right things. And you're not, for example, stuck in a penalty investigation or in the context of a Section 15 investigation with the bad email from customer service or the bad email from an engineer without further documented context for what happened after this engineer, said this thing? Did he just scream into the void and get ignored? That's a basis for penalty. Or did that get considered and discussed and then was determined that it was an isolated incident for these other reasons that are not likely to recur? I mean, those are the kinds of things that, those discussions are often happening, but if there's no paper trail to record them, there's nothing to turn over to your regulator to show that you did exactly what they've told you to do. Similarly, not letting customer service records just sit with these, really severe characterizations of what happened to a consumer without probing further, so that, when you do get a request for a full report, now you're having to turn over 30 reports of a fire without any accompanying medical information or property damage because you just didn't ask. Making sure you're collecting information to be able to protect yourself.
On the question in the chat about the staffing, what staffing does CPSC look for? I haven't personally experienced the CPSC scrutinize the number of employees involved in a product safety compliance program, because usually an issue is discrete enough to where the people who are involved in it are, a distinct set of people, and it's less about kind of how many people are involved overall. But I think that adequate staffing or inadequate staffing, to the extent it potentially contributes to the problem, would be something that the CPSC would seize on, especially if that was shown in the records.
Well, and certainly the qualifications of the product safety professionals who are working on that, if they have no background, no training, they're not engineers, whatever, I think that would look like. So the last thing you want to do is to create a great program on paper that is not effective because you don't really implement it, and you're not confident that it is effective in doing what you want to have done. So when we create product safety policies, I always tell companies, don't promise to do something that you're not prepared to do. Don't do it just to show to a jury and make it look like you're a good company or the CPSC. So you want to have good people, adequate number of people, which is an open question, who are trained and knowledgeable about how to do safety. And one, hopefully that'll help you prevent safety problems, and two, be able to defend yourself against CPSC or a plaintiff's lawyer in the event you ever have to.
And one thing, just for the 70 people who have held strong here past 2 p.m., which we apologize for, I just want to touch on, because I think it's really important. Having this type of program can not just keep you out of civil penalty issues, it can keep you out of criminal penalty issues. And to the extent that anybody inside of your organization is looking at criminal penalties and saying, oh, that's just GRE, that's different, that's a case that's not, the CPSC has moved that line. We have seen criminal investigations open. We've seen criminal target letters sent involving a lot less egregious conduct than what you would look for and what you would see in GRE. And so that is something to really kind of be mindful of, that this is not just protecting you from uncomfortable penalty and that type of investigation. The criminal side is not just looking at corporate, it's looking at individual executives as well. And so, and it is real. And something not just we, but other firms that you would know have experience with and are working on right now. And so that's just something to kind of put that's not just a throwaway anymore in terms of like, oh, there could also be criminal penalties. It's real, and there are investigations. DOJ is still around. It's in a different format, and there's actually 2 divisions now that have responsibility for CPSC criminal investigations, and they are not slowing down.
And on that happy note, thank you very much. We'll end the programs. Thank you, Matt. Thank you, Elliot. Thank you, Asha. We really appreciate it. This is not the end of the conversation. Next year, maybe we'll drill down on some of those compliance requirements in more detail. Just take a single one and go through that in detail to see if we can understand in more detail what's going on. The slides will be posted. There'll be additional material, articles, or other things that we'll post on the website available, and as well as a link to the video of the program. So take a look later on and you'll see some other information. And we appreciate, again, Sedgwick for sponsoring the program. And thank you all for attending today. Thank you all.
Thanks, everyone.
Thank you, Ken.
Thanks. Bye-bye.
Thanks.
Yeah, bye-bye.